Well, good morning, everyone. Director Bartelauskis and Ms. Fernandez, I'm grateful to you for having invited me to come to this seminar. It's not the first time I've been here. On previous occasions, and those who have heard me previously will know actually that I have a family background because my own family comes from Estonia in times in the past. They left after the revolution in 1917, but we still have strong ties to what we call the Baltic states, especially in my situation from Estonia. And it's a pleasure to be here in Liepāja, or Liepāja as the Germans used to call it. And I'm grateful again to being invited here, and my appreciation also goes to the Honorable Judge Peterson from the Supreme Court, and I'm hopeful that my contribution this morning can contribute to your understanding of what we talk about in intellectual property law. I have not much time, essentially 40 minutes, and if I go a little bit beyond that, someone will have to stop me. What am I doing? I give a short introduction, and then I essentially talk about cases decided by the Court of Justice of the European Union. What are current issues, just to highlight that we're not only in the IP field talk about case law or judges. For those of you who think back, they will know that 50 years ago, the European Patent Convention was signed in Munich, the famous Münchner Patentübereinkommen or European Patent Convention 50 years ago. We have, of course, this year in June, the starting of the Unified Patent Court, and it's, of course, a great honor and privilege to have here Mr. Gawinski, the director or the president of the Unified Patent Court. We have design law reform in the European Union, following proposals by the European Commission in November last year. The Council has been debating and negotiating a new directive on design law, and I'm sure that you, Director, have been participating in these sessions in Brussels. And in June this year, the Council agreed on a common position which will be formalized sometime in September, and then we'll go into the trilogue with the European Parliament, and everyone hopes that the design law reform will be finally adopted before the elections of the European Parliament next year. So we are looking forward for the new directive, which will have a 3-year transition period, and we will have an amended regulation on design law. There's also new legislation on its way in regard to the protection of geographical indications. The non-agri or the handicrafts and industrial products designs regulation is on its way to be adopted by Parliament in its next session in September, and the agri regulation is in the process of being amended and will probably also see its daylight by the end of this legislative session. Then you have very recent new legislation dealing with supplementary protection certificates, and those of you who participated last year will know that the Honorable Judge Burrs from the English Court of Appeal explained how SPC, these supplementary protection certificates, are working, and we also have a proposal on its way from the European Commission dealing with the licensing of standard essential patents. So the field on new activities is full with issues. I'm just highlighting these before I turn to EU Court of Justice case law in intellectual property cases. There have been a total of 19, the period that I'm discussing is from the 1st of September last year until the 31st of August this year, so it's a full year of judicial activity rather than using the annual year, it's perhaps, since these conferences take place in September, to do this year round. We have 19 cases, 4 cases dealing with general issues not linked to a specific intellectual property right. We have 4 copyright cases. We have 9 trademark cases and 2 design cases. I will not be able to deal with all of these 19 total cases, but we'll have a selection of these issues. Just to begin again, a short mentioning the jurisdiction of the European Court of Justice is, as you of course know, on the one side, on preliminary rulings referred to the Court of Justice by national courts. That is Article 267 of the Treaty on the Functioning of the European Union. I have these provisions on my slides. I'm not going to talk about them, just for your memory, and it may be helpful to review these provisions and how they come from. The other jurisdiction of the Court of Justice is on appeals from decisions of the General Court. You know, the Court of Justice is composed of 2 courts, the General Court and the Court of Justice. The General Court deals with appeals, with actions against the community institutions, including actions against decisions taken by the EUIPO, European Union Intellectual Property Office, in trademark and design cases. Specifically, its decisions appealing against rulings of the Boards of Appeal of the EUIPO. The Boards of Appeal of the EUIPO decide between 2,000 and 3,000 cases a year, and about between 200 and 300 each year are appealed, so about 10% go to the General Court. The General Court's jurisdiction, and we have Mr. Stech here, who will be speaking to you at later occasions, is much more familiar with this than I could be, will tell you that of these about 200 to 300, depends, let's say 280 cases a year, about 10 to 15% are still appealed to the Court of Justice on points of law. Since the new procedure adopted in 2019, the Court of Justice has a procedure of admitting such appeals, points of law, and in the course of these 4 years since 2019, the Court of Justice has admitted a total of 3 trademark cases for appeal, 1 design case, and 2 cases which also come from the trademark side but actually deal with non-trademark issues, namely representation by lawyers before the General Court, and whether the court is obliged before dismissing an appeal by order to give opportunity to parties to comment on its proposed decision. So these cases have been accepted. None of them has been decided yet. In the design case, we have an opinion from the Advocate General. This is the question of these priority claims for designs, whether they can be based on a patent application and what the time limit is. And in one of the trademark cases, we're going to have an oral hearing, I think, next week on the issue of the proper point in time to take into account earlier rights. This results from the Brexit situation. So if you look specifically at trademark cases and design cases, the jurisdiction comes from provisions in the European Union Trademark Regulation and in the Design Regulation. That's very kind of you. So before going into these, I have 6 or 8 cases that I'm going to deal briefly with you. I just give you another statistics which you may find interesting. If we look at preliminary rulings, that is essentially what is currently decided by the Court of Justice, and look where these preliminary rulings have their origin. In in the last 5 years since 2018, courts from the Baltic states have referred cases to the Court of Justice as follows: Estonia 14, Latvia 50, and Lithuania 41. If you compare that with references from other acceding states in 2004, for example, Slovakia has referred 31 cases in the same period. In Germany, we have 536, in France 140, and the Netherlands, smaller country, 136. So we have a total in these 5 years of references to the Court of Justice amounting to almost 2,900 cases. And of course, your countries here, by population and by tradition, may not have the same urgency or need, but of course, if a case reaches your highest courts, you must refer cases to the Court of Justice when the ruling depends on an interpretation of EU law. The first case that I want to mention is a ruling that came down in April this year on a reference from the Finnish Supreme Court. It has to deal with the jurisdiction of European Union trademark courts. European Union trademark courts, as you are familiar, are those courts which are competent to deal with infringement actions relating to EU trademarks and counterclaims. They have exclusive jurisdiction for these cases, and the legislation for the international jurisdiction is set down in Article 125 of the EU trademark regulation. And there is specifically a rule in paragraph 5 of this article of the regulation according to which those courts have jurisdiction in that member state where acts of infringement have been committed or threatened. This is the Forum Delicti Comissi, and these courts, different from courts at the domicile of the defendant, the courts in this Forum Delicti Comissi have jurisdiction limited to their specific territory. And if you look at the facts of this case, the issue was that, a Finnish company has a European Union trademark. 2 German companies are the one by buying an AdWord, which is displayed when you enter a search engine in Finland. The other one by showing pictures on a generic website, in this case Flickr. Those of you who are familiar with the websites will know Flickr is a picture sharing website. So these 2 German companies are displaying products under a trademark which the Finnish claimant claims is his own or is identical to his own trademark. So he brings a case in the Finnish court against the German defendants, not in their domicile, but in the place of alleged infringement, claiming that when you enter the search term in the search engine, in this case Google, the advertisement of that particular German company is visible in Finland. And if you also enter into the search term, in the search engine, this term, the pictures displayed on Flickr will show the product of the German company. So the question was, is that activity which comes from a German company on a website accessible in Finland sufficient to establish jurisdiction on the basis of acts where infringement have been committed or threatened in Finland? And that was referred to Court of Justice, and the Court of Justice in this ruling said more or less the following. Having an AdWord which allows a search engine then to display an advertisement of the German company in Finland, and this on the basis of acceding the Google search engine with a Finnish domain. So it's Google google.sf or google.fi as it is in this case, that is sufficient to establish jurisdiction of the Finnish court for the infringement of its EU trademark in Finland. On the other hand, the display of a picture on a generic website, even though it is acceded on to this through the search engine of Google, is not sufficient because it is not specifically or enough directed to the Finnish public. This case adds on to established case law in a case called AMS Neve by the same Court of Justice, where from a website in Spain, activity was directed toward England, and on reference from the English Court of Appeal, the Court of Justice there held that the activity of addressing customers in England is sufficient to establish jurisdiction in England. The practical issue of this is for litigants like ours, that when advising clients and seeking to have a jurisdiction in your own country, for example in Germany, we will look to a situation where activity is directed at German public or German customers, and then we can sue in Germany or in France or wherever, and the consequence is, of course, that the judgment is limited to the territory specifically, but you can, and in this case the Finnish company felt obviously more comfortable to bring the case in Finland rather than in Germany. You can use your own lawyers and your own language, so very important further development. The second enforcement issue that I want to raise is the following. You have, and I'm sure you're all familiar with this, the directive on the enforcement of intellectual property rights adopted in 27 April 2004. That's significant because that was 3 days before or 4 days before the accession of new member states to the European Union. So this directive was negotiated and finished just a few days before the accession of the new member states, which then had to take it as it was without having participated in the negotiations. It is a very important basic law, maybe not necessarily recognized everywhere in the European Union, on basic rules and principles for enforcing intellectual property rights, from general issues like proportionality and effectiveness to very specific points like damages, injunctive relief, preliminary relief, requests for information, and this directive has increasingly become subject of references to the Court of Justice. And the case that I have here is one of these cases decided also in April this year. It's from a Polish court and involved an infringement, in this case, of a copyright where actually I have the facts here. You may wonder whether these are kind of tiles with inscriptions, whether they fulfill the copyright level of originality required. Anyway, the plaintiff in that case claimed that the defendant were infringing their copyright in these placards or these tiles or whatever you call them. And as a preliminary measure, the plaintiff claimed information from the defendant about the origin, the distribution channels. It's one of the claims that the Enforcement Directive specifically provides for in Article 8. The holder of an intellectual property right is entitled to claim information from an infringer about origin, distribution channels, and so on. Now, all member states have, of course, implemented this provision, but when you get to the Court of Justice, they usually only look at the interpretation of the directive rather than at the national law, because they cannot interpret the national law. So the question there was, what does the plaintiff have to show in a request for information? Does the plaintiff, the claimant, have to provide full evidence of ownership of copyright in this specific case? So that raises the issue of, in a preliminary proceedings or in this kind of claim for information, to which depth must the court go in investigating whether the claimant is actually the holder of a title to copyright? Does the claimant have to provide full proof, or is it more like a prima facie case? And this question was referred by the Polish court, and the Court of Justice said it is sufficient under Article 8 of this directive for the claimant to provide reasonably available evidence, sufficient degree of certainty that the applicant is actually the right holder, by submitting evidence appropriate to the nature of that right and any special applicable formalities. Formalities refers to things like certificate of registration, which is, of course, the main means of proving title in trademark cases. So this is a general proposition, reasonably available evidence, sufficient certainty, which then leaves it to the referring court to decide whether in the particular instance the case will, of course, go back to the Polish court. That requirement is fulfilled. My message on this particular case, and I would like to repeat that again, is the significance of the enforcement directive for essentially all issues today of enforcing intellectual property rights, from injunctive relief to damages to preliminary remedies like in this present case. I will now come to the 4 trademark cases that I would like to present to you that have been decided by the Court of Justice in this period. And certainly the most important one is the Louboutin cases decided just 2 days before Christmas last year as a Christmas gift to the trademark and design profession. As a background, one must know that litigation against internet service providers and platforms has been one of the most difficult issues that has been faced by the Court of Justice. And in previous years, they have essentially liberated internet service providers and platforms from liability by holding, for example, that Google, when it sells AdWords for commercial presentations on its website, that Google is not using the trademark and therefore is not liable for infringement. They have had a case against Amazon, where Amazon was operating a marketplace where it was offering not its own products, but the products of sellers. Google, as in Google, in this case, Amazon, was not liable because it was not using the trademark which the seller was using. And so you have to sue the seller, but you cannot go against the platform. There is some previous case law relating to eBay, also decided by the Court of Justice, where it was held that in the moment when the internet platform itself becomes active in the offering or sale or distribution of potentially infringing goods, it may actually be held liable. There's an interplay between the e-commerce directive and trademark regulation, and that case law is still developing. Now, the Louboutin cases were referred to more or less at the same time from a Luxembourg court and the Belgian court, and I have kind of outlined the facts here if you later want to look at it. What is happening is that Amazon has a different mode of operation now than it used to have in the past. If you go and enter a product search on Amazon, you find Amazon products, their own products, and you find sponsored products, which are called sponsored, which are made by independent offerers or sellers who use the Amazon platform. And Amazon becomes involved in stocking these products and transporting them, but the seller products are not Amazon products, they are third-party products. And in the past it has been held that for these third-party products, the third parties are responsible for infringement. Now here, under this new approach, the Court of Justice says essentially the following. The moment that the internet, the platform, in this case Amazon, presents the products in parallel, its own products and the products of the alleged infringing goods, and it is difficult for a reasonably attentive internet consumer to make a distinction whether this is an Amazon product or not. In this situation, Amazon may itself become liable for having on its platform infringing products. And that's a new departure, because in the past we had the impression that the Court of Justice was quite willing to exempt the internet service providers from liability, and now this is a significant departure, and I have highlighted, if you look at the answers to that the court is giving in the Louboutin case, if a well-informed and reasonably observant user of that site establishes a link between the services of that operator, that's Amazon, and the sign and issue, that's the infringing sign, which is in particular the case where, in view of all the circumstances, such a user may have the impression that the operator itself is marketing in its own name these signs, then there is infringement. Important issue now, and we in our own practice are now having cases where we are trying to implement that in further proceedings against Amazon. My next case is another Finnish reference, and it has to deal with what we call exhaustion. Sorry. There is a company, I'm sure you're familiar with, called SodaStream. They are selling a product where you use your normal household water and you put carbon dioxide in it and you can make drinks out of it. And SodaStream, busy essentially everywhere, is selling machines, and it's selling capsules which contain carbon dioxide replacements to put in their machines. And there's a second market, or secondary market, where, I'm very sorry, my voice is kind of... There's a secondary market where companies are competing with SodaStream, and they are using their own cylinders, and they're using cylinders previously sold by SodaStream for the machines, and they refill them with their own carbon dioxide. Now, these cylinders that SodaStream makes have not only a paper label, but they have an engraved SodaStream trademark on the capsule. So it's kind of difficult for the people who get these used capsules and want to fill them with their own carbon dioxide. So what do? They either, or in this case what they do, they put a separate label on it and say, this is not Soda Club, but this is SodaStream. We are not Soda Club, we are SodaStream. And it's refilled by SodaStream and no relation to Soda Club. But on these capsules, you still have visible the original engraved Soda Club trademark. And the question is that infringement of the trademark of Soda Club? So you are in a field which we might call refill of used products. And there is a previous case law, Viking Gas, having to deal with the refilling of gas bottles. It's exactly the same situation. And you have a different kind of case law on refilling or rebranding or debranding, which comes from the field of pharmaceuticals and the exhaustion of pharmaceutical products in the European Union. At least 25 cases I could cite to you having to deal with this parallel trading in pharmaceutical products. And the Finnish court asked the question whether the so-called Bristol-Myers criteria on refilling and rebranding apply. These are the pharmaceutical principles, or what else is the law? And perhaps to no one's surprise, the Court of Justice in its judgment in October last year simply disregarded all the cases that have come from the pharmaceutical field. So it's not this kind of case. And they decided more or less along the line of the refilling of the gas bottles that it will depend on the circumstances. That is to say, there is no absolute right of the soda club people to prevent the refilling of their own capsules, which have been sold. They are free on the market. But it will depend on whether the public to whom these labels that the SodaStream people put on is able to distinguish between the SodaStream and the Soda Club products. This may be difficult in the individual case, and I'm sure that the Finnish court will have its own problems in solving that, these individual issues, but it's an important case out of this whole sequence of what we call the exhaustion exception to exclusive rights. I now have two cases which I'm going over this one and I leave it for you to read. I have two more cases that have to do with the procedural issues specific to trademark law. When someone brings an infringement action in the EU trademark court, the defendant, as a means of defense, has several possibilities. One is to say, I'm not infringing, straightforward. The other is, the trademark which is being asserted is invalid. And of course, you cannot infringe an invalid trademark. So the question is, how does the defendant do that? There are two possibilities. He can go to Alicante and file an application for declaration of invalidity or revocation, or he can bring a counterclaim in the infringement court. This happened in this particular instance in Germany, where a trademark, I don't know whether you're familiar enough with German to understand the word Apfelzügle. It's a little apple train which was running in the harvest time when apples were harvested near Ludwigshafen. And someone had registered Apfelzügle as a trademark and then brought a case against someone who was running an Apfelzügle in the same region. And not surprisingly, the defendant counterclaimed for invalidity. The case was reached a situation where the mark was in part invalid, then an appeal was filed, and the plaintiff, again not surprisingly, withdrew his infringement claim because he found it, we could not possibly succeed with his claim. The question was, what happens with the counterclaim? Infringement claim withdrawn, counterclaim, is it still pending? And who decides what happens with it? Is this a question of national procedural law, or is this a question of European Union law? And the Oberlandesgericht Munich wasn't sure about the answer, and referred the question, what happens when infringement claim is withdrawn with a pending counterclaim for invalidity? And the Court of Justice said it remains pending. It didn't even look at the issue as one of national law. It decided this as a matter of European Union law. Article 128 of the EU trademark regulation, which provides for the counterclaim, now means that regardless of what your national law has on counterclaim pendency, it remains pending when the main action is withdrawn. That's the first counterclaim issue. And now is the second one. That's this one. Just a minute. Something went kind of mixed up in my slides. Anyway, the second case is this one, decided only a few weeks ago on the 8th of June, a reference from a Polish court LM versus KP, you can no longer decide who these are because the Court of Justice has begun to anonymize parties' names. I don't really understand why, but maybe someone else has an answer to that. So we have this case, LM versus KP. You have a trademark in Poland where the issue was where the issue was infringement of the trademark. Counterclaim for invalidity, which was directed against the trademark as a whole, not only against the goods and services on which the infringement claim was based. The court decides no infringement for those goods which claim to be no infringement. Question, what happens with the counterclaim which is directed against all the goods of the earlier trademark, not only the ones which were at issue in the infringement or related goods. So the court asked the question, in such a situation where a counterclaim is directed against more goods and services than against those which are relevant for the infringement, is the court obliged to make a decision also on these other goods? Now, we call this in procedural law, and you may have the same issue in your own national procedurals, whether a counterclaim must have some connection with the main claim in order to be admissible in the first place. We call this connexity, and the issue is in dispute in Germany to which degree the counterclaim must deal with essentially the same broad subject matter as the principal claim. And apparently the Polish court had the same difficulties, referred the case to Luxembourg and asked the question, must there be a link between the counterclaim and the main action for infringement? And the Court of Justice said no. The counterclaim is totally independent. It's an alternative means of asserting the validity or invalidity of the earlier right, regardless of the scope of the principal action. And the Polish court will therefore be obliged, even though the infringement case is over, now to decide on the validity of the asserted trademark for all the goods and services, unless, of course, the plaintiff or the counterclaimant will decide to limit its claim. But it's, again, a point of interest that the Court of Justice does not even wish to look at what the national law says on scope of a counterclaim. It merely concludes by looking at the language of Article 128 that this is an alternative to the action before the case is brought in Alicante. Very important principle. The 10th Chamber decided this case even without asking an Advocate General for its opinion. It's written by Mr. Gracias, who is actually the current presiding judge in that chamber. Now, I know my time is finished, and I still have two non-trademark cases designs, which I leave with you. I have provided you with much more information on my slides than I could possibly present in 40 minutes. I'd like to refer also to a long paper, some 30 pages of EU Court of Justice case law in intellectual property cases in the same period. There is a complete statement of what the issues are and what the conclusions are, and so I recommend that for your attention. I remain in your presence here for the remainder of this event, and I do thank you for your attention and my excuses for somewhat overstepping my time. Thank you very much, Mr. Watt.